Yeah, I found some royalty-free background music because I just can't stand the silence. If that's too loud or too quiet or in the way, let me know. All right. Who's Raffin? I don't know. I'm not gonna figure out who these people are. All right, let's go. So, starting at the top, all the regular stuff, Supreme Court, TLC versus RFS, yada yada yada. The same, defendants, third parties. Yeah, reasons for judgment. So before the Honorable Justice Thompson, reasons for judgment regarding publication of disclosure material. These were the four lawyers that me and Jimmy Thompson were up against. Um, Lauren Phipps, he's doing a lot of the prosecution for Fairy Creek stuff. Um, Very like decent to deal with. Like I will say, uh, it was a pleasurable. Um, he was mindful of the fact that we were self-representing and was easy to work with, easy to talk to, um, and yeah, good dude. All things considered. Leslie Rizika, on the other hand, I'm sure she's good at her job. Let's say that. I'm sure I'm sure she is, a respected lawyer. And David Kwan, David Nunez, we barely saw them. AG of Canada didn't really have much to say in the proceedings. A lot of it was co-signing what uh, the BC AG was saying. Um, Jimmy Thompson, yeah, he was named. He's the respondent. And then C. Ruiz, myself. Um, Yada, yada, yada. Ta-da. Okay, paragraph 1. Yeah, Mackenzie, let's talk to me in person about her, and I'll be more candid. Um, yeah, Mackenzie on Instagram says she got hired for a reason. In quotes, I'm like, yeah, that's a really polite way to describe it. Um, Again, if you're on Instagram, I'm on Twitch where you can see my screen and I talk about the whole thing. And you can chat with me if you want. I can't really. Messages on Instagram just disappear, so I don't see everything. And if you don't know what Twitch is, you're one of my boomer followers. And good luck. Um, Paragraph 1. Prosecutions for criminal contempt are underway against more than 400 persons who are alleged to have acted in criminal contempt of an injunction order obtained by the plaintiff logging company. Excuse me. This is the Crown's application, supported by the AG of Canada, appearing for the RCMP, to enjoin the alleged contemners or anyone with knowledge of the proposed order from publishing disclosure material. 2. Paragraph 2. An undertaking of confidentiality attaches to Crown disclosure. In fact, in accordance with its practice, the Crown expressly advised the disclosure recipients that the material was delivered on this undertaking. Portions of the Crown disclosure came into the possession of journalists, the application respondents Cameron Ruiz. I cannot tell you how predictable and fucking annoying it is that I have been called Cameron in a legal decision from a judge. How hard is it to misspell my name? My name is in the document, in the affidavits. And this is what kids in grade school would call me when they didn't know how to say my name, because they thought Cam was short for Cameron. They're like, Cameron. I'm like, dude, I could wear a name tag and they would still call me Cameron. So, big negative points for Justice Thompson. A little upset by that. Anyways, no, because it's. I mean, I wish, but like, he knows who I am. I know he's referring to me. It's like common sense. It wouldn't void anything. And I emailed them, and they're going to correct it, obviously. And Jimmy Thompson, the managing editor of the Capital Daily, which is published by Overstory Media, Inc. As described in open court, Mr. Ruiz received some McNeil disclosure regarding disciplinary proceedings against RCMP officers, and Mr. Thompson received a collection of open source social media material assembled by a person retained by the RCMP to assemble this information. When the Crown became aware that this material was in the hands of journalists, it applied to prohibit the publication of any disclosure information. An ex parte interim order was made on 23rd of January 2022 and extended by consent until the journalists were given an opportunity to be heard. I mean, yeah, I wish it voided it, but, I'm the one that appeared in court twice. Like, obviously it's me. And they do revise these decisions pretty frequently to make edits and corrections. So they'll just republish one like later today or tomorrow with an edited version. Like, I'm not going to call the Supreme Court to make a fucking fuss. They've had enough of my money and attention. Where were we? We're up to... Mr. Thompson received a collection of open source social media material assembled by a person retained by the RCMP to assemble this information. That's, to put it in plain terms, a third party collected open source social media material on behalf of the RCMP, and that data was given to Mr. Thompson, to put that into plain speak, kind of. When the Crown became aware that this material was in the hands of journalists, it applied to prohibit the publication of any disclosure information. An ex parte interim order was made on 23rd of January 2022 and extended by consent until the journalists were given an opportunity to be heard. Did I not just read that? Paragraph 3. This application features a head-on conflict between two public interests of utmost importance: protecting the Section 2A Charter right to free expression and protecting the proper administration of the criminal justice system. The court must balance these important interests to decide this application, and regrettably, an important public interest must give way. To those on Instagram, the link is in my bio to my Twitch account, and I'm streaming there, where you can see my monitor and what I'm reading, and also chat with me. Okay. Sorry, I went really fast through that. So yeah, those are the two interests he has to consider: the right to charter right to free expression, and the protecting the proper administration of the criminal justice system. Background. A lot of the stuff, we already know, but we'll go through it. Teal Cedar holds Tree Farm License 46, a forest town here in southern Vancouver Island. The license area is nearly 60,000 hectares in size, and it contains stands of old growth. It overlaps with the traditional territories of the Patchedat First Nation and the Dididat First Nation. Teal Cedar has been granted permits to cut timber and to conduct road building activities within certain parts of TFL 46. In August 2022, protesters blocked roads at various locations in and around TFL 46. They were unhappy with the prospect of old growth logging. In September 2020, the provincial government announced a deferral of old growth logging in 9 areas. That's 2021. Right? Yeah, that's 2021. Get your facts straight, Thompson. Sleeping. The provincial government has a deferral of logging in 9 areas of the but TFL 46 was not included. Road blockages continued. TL Cedar commenced this proceeding seeking inter alia, I don't know what that means, injunctive relief, and an interlocutory injunction order was made in April 2021. Oh, maybe they did make deferrals in September, and I just don't remember, or wasn't paying attention then. Justice Verhoeven's reasons for granting the injunction are indexed at blah blah blah. Paragraph 6. The injunction order contains police enforcement terms. The police began enforcement operations in mid-May 2021. I was appointed management judge for this for this litigation in May 2021, and I have decided a series of applications, including the application by the plaintiff seeking a court invitation to the Attorney General of British Columbia to become involved in the prosecution of the contempt allegations. I issued that invitation in July 2021, and my reasons for doing so are indexed at TL Cedar, blah, 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 blah. Paragraph 7. In the meantime, after issuing the invitation to the prosecution service, I heard applications by members of the public and a consortium of media organizations aggrieved by the RCMP's policy of restricting access to the injunction area by means of expansive exclusion zones, checkpoints, and searches. The media applicants also complained about the RCMP policy of shepherding journalists while they were in these exclusion zones. One experienced journalist who has reported on all manner of police events in Canada and elsewhere in both rural and urban settings, including civil disobedience events, deposed that in every other democratic society he has worked in, he has been allowed to do his job without police escorts and exclusion zones. On the other hand, the level of police restriction on journalist movement in TFL 46 was familiar to him from his work in China, where he was accompanied by police who decided what he was allowed to see. A little bit of xenophobia in there, but at the same time, like, China does track journalists and media and follow people and tell them what they can and can't do. Not to the extreme that other authoritarian regimes do, but like China does it. Like, they control what comes in and out media-wise. In ruling on the access applications, I concluded that an important purpose of the injunction is to maintain public access to roads in the injunction area. To those that just joined on Instagram, the link is in my bio to Twitch, where you can see my screen and chat with me there. Okay. I concluded that an important purpose of the injunction is to maintain public access to roads in the injunction area. The RCMP were blocking vehicle access to roads that serve as the main entry points to these public lands, and this was directly at odds with this purpose. I also held that the RCMP's expansive exclusion zones, and associated checkpoints and searches were unlawful because it had not been established that these measures were reasonable and necessary to carry out their duties. And I granted the media consortium's application for a variation of the injunction in order to add a direction intended to control interference by police with the work of journalists. The BC Prosecution Service, on behalf of the AG of BC, took up this court's invitation to assess whether prosecutions for criminal contempt of court should be pursued in relation to alleged contempt of the injunction order. In the result, the Crown has assumed conduct of more than 400 prosecutions, and the Crown has provided Stinchcombe, including McNeil, disclosure to alleged contemptors. Okay, nature of, let's make sure I'm recording. Okay. Nature of the application, paragraph 10. These prosecutions for criminal contempt are in substance and purpose ongoing criminal proceedings, albeit occurring under the rubric of a civil action. See, names a bunch of court cases, blah, 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 blah. They're just stating that like, these are criminal proceedings, even though this was a civil matter, that they've been escalated to criminal contempt. Paragraph 11, in accordance with the nature of the proceedings, the Crown has provided disclosure to alleged contemners for the purpose of facilitating their right to make full answer and defense. The Crown made its disclosure on the express basis that the material is provided for this purpose and that the disclosure material must not be copied or provided to any other person other than legal counsel. Even if the Crown had not expressly set out the conditions upon which the disclosure was provided, there is an implied undertaking that attaches to discovery material. Oops. He just puts Juman v as an example. So Juman is a court case that comes up later on. We'll get to that. Oh, no, sorry. To discovery material, Juman v. Doucette, 2008, Okay, that is the case. And this implied undertaking extends to criminal cases, R.V. Moazami, R.V. Bassi, where in the past the implied undertaking has been shown to be ineffectual, this court has prohibited an accused from distributing or otherwise publishing disclosure. R.V. Beckett, 2015, yada, yada, yada. 12. The order sought would enjoin distribution or publication of the disclosure and appears in a remedial sense to be a form of injunction. Yeah. That's fair. Like, what they are seeking is, an injunction preventing us from publishing. He gets into like the legal definitions of this type of thing, and anyways, we're going to get into it. If you have questions about some wording, please let me know. However, the Crown emphasizes that it does not rely on the court's authority to issue injunctive relief. Rather, it bases its application on the court's reserve of powers available to a criminal case management judge. And R.V. Bassi held that these, Justice McKenzie held that these inherent case management powers confer a broad discretion to ensure the effectiveness of the implied undertaking rule. The respondents submit that the circumstances do not support the exercise of this discretion, but I do not understand them to dispute the court's authority to make the order sought in appropriate circumstances by making use of this reserve of case management powers. Okay. That's a long run-on sentence. It's basically saying that, we do not support the use of, the court's discretion to issue just broad publication bans, but we don't dispute its authority to do it. That said, I appreciate that jurisdiction cannot be conferred by consent or in absence of opposition to its exercise. I am satisfied that I have the inherent jurisdiction referred to by McKenzie in R.V. Bassi if I am persuaded that the use of this jurisdiction is required to uphold the effectiveness of the undertaking accompanying the Crown disclosure. Okay, paragraph 13. There's another aspect of this matter that is not contested. The issue of this application is not whether the alleged contemners ought to be enjoined from breaching their undertakings. It is highly likely that at least one alleged contemner has been non-compliant with the conditions on which they received disclosure. I make the order prohibiting the publication or distribution of disclosure by alleged contemners without hesitation. The issue in this case is whether the non-publication order ought to be extended to journalists who have come into possession of disclosure material. Here we go. The Crown submits that this application is governed by the Supreme Court of Canada's decision in Juman v. Doucette, such that the respondent journalists must apply to access and publish disclosure documents that are subject to an undertaking. The journalists argue that Globe and Mail v. Canada requires a Dagenais-Mentuk analysis. Each side submits that it ought to prevail regardless of which test is applied. So there was a lot of talk about R.V. Bassey, Juman, and Dagenais-Mentuk when we were in court. I did not have the capacity to research. I started recycling the documents they gave me. They had two giant binders full of 26 different decisions by courts that they were using to make their argument. It was pretty massive, and I just didn't read it. I couldn't. There's no way I was going to be able to get through it. But yeah, so I won't have a definition to like break down now, but this is the one that kept coming up. And yeah, I would love to do a deep dive on this later, because it really does seem like the most recent and relevant, like, standing test for not disclosure, but for publishing of confidential material. Anyways, in Juman, police authorities applied to obtain discovery information produced. If you're on Instagram, the link is in my bio on for Twitch, where you can see my screen if you want to watch there. Okay, paragraph 15. In Juman, police authorities applied to obtain discovery information produced by a party in civil litigation in order to further a criminal investigation. The Attorney General of British Columbia argued that it would be contrary to the open court principle to disallow production to the police. However, the court unanimously rejected this argument, citing a series of cases including blah, blah, blah. Justice Binney offered that there is an undertaking to the court that attaches to the discovery material. The undertaking provides an assurance that the material will not be used for a purpose collateral or ulterior to the proceedings, thereby encouraging a more complete and candid discovery. Thus, the undertaking is supported by twin public interest rationales: privacy interests and the importance of allowing the truth to emerge by encouraging candid discovery. The court acknowledged that the privacy interests and the interest in efficient conduct of litigation are not absolute and may be trumped by a more compelling public interest. In order to obtain relief against the undertaking, the applicant, whether a party to the undertaking or otherwise, must satisfy a court on the balance of probabilities of the greater weight of this countervailing public interest. Blech. These guys really love to make one sentence a whole paragraph. Okay, it's two sentences, sorry. I'll read that again. The court acknowledged that the privacy interest and the interest in the efficient conduct of litigation are not absolute and may be trumped by a more compelling public interest. In order to obtain relief against the undertaking, the applicant, whether a party to the undertaking or otherwise, must satisfy a court on a balance of probabilities of the greater weight of this countervailing public interest. That kind of like sets the stage of like, yeah, like how to overcome it. Okay, 17. The court made it clear that an applicant seeking to vary an implied undertaking faces a high hurdle. Paragraph 32, in this decision, what is important in each case is to recognize that unless an examinee is satisfied that the undertaking will only be modified or varied by the court in exceptional circumstances, the undertaking will not achieve its intended purpose. As stated, the onus in each case will be on the applicant to just demonstrate a superior public interest in disclosure, and the court will be mindful that an undertaking should only be set aside in exceptional circumstances. An undertaking designed in part to encourage open and generous discovery by assuring parties being discovered of confidentiality will not achieve its objective if the confidentiality is seen by reluctant litigants to be too readily set aside. Okay, paragraph 18. At paragraph 36, Justice Binney referred with approval to Livent versus Drapinski, wherein Justice Lederman concluded that a non-party may apply to vary an implied undertaking, but the applicant in such cases bears a particularly heavy burden of showing cogent and persuasive reasons why leave should be granted, and that leave to disclose is virtually never given. Yeah. Paragraph 53, Justice Binney reiterated that success on such an application would be unusual, and he made these further observations. Of course, if the undertaking is respected by the parties to it, then non-parties will be likely to possess enough information to make an application for a variance in the first place that is other than a fishing expedition. They use this term a lot, and yeah, Thompson used it in court, where he basically said, he referred to journalists looking for data as a fishing expedition. You know, you're just like casting a line or net and hoping you get something, and how that is ineffective and not a solution. Like, that's not the way that journals should have to operate when dealing with the government and Crown. But the possibility of third-party applications exists, and where duly, excuse me, and where duly made, the competing interests will have to be weighed, keeping in mind that an undertaking too readily set aside sends the message that such undertakings are unsafe to be relied upon, and will therefore not achieve their broader purpose. Okay, paragraph 19. I turn to the Supreme Court of Canada's decision 2 years later in Globe and Mail. In that case, the newspaper published leaked aspects of confidential settlement negotiations in litigation flowing from the sponsorship scandal. During the hearing of an application in the litigation, a Chambers judge made an order prohibiting further reporting on the state of these confidential negotiations. This order was made on the judge's own motion and without hearing submissions. The newspaper was surprised by the order and objected to what it characterized as a publication ban, but the judge maintained that his order was not a publication ban. Justice Liebel wrote for a unanimous court. He rejected the submission that the judge's order was not a publication ban and the companion argument that the Dagne-Mentek framework did not apply. Justice Liebel held that the order must be assessed for what it looks like and sounds like, and in fact is, a court-ordered publication ban. The order was made in the context of a judicial proceeding and limited freedom of expression by the press, and applying Vancouver Sun something case, it followed that the Dagne-Mentek framework was applicable, and that the Chambers judge erred in not applying this framework before making that order. Justice Liebel did not make express reference to Juman, but he did refer at some length to his reasons for the court's pre-Juman decision in Lac Damiant, a case that specifically considered implied undertakings and their rationale. And notably, Lac Damiant, I'm probably mispronouncing that, was reportedly referred to with approval in Juman at paragraphs blah, blah, blah. What follows is from Globe and Mail. It is important to pause and reiterate here the importance placed by both the judiciary and the legislature on confidentiality at the pre-trial stage, whether the proceedings are examinations for discovery, mediation, or settlement negotiations. It is also important to note that the rationale animating the confidentiality undertaking in all of these contexts is the same. In Lac Damiant, this court concluded that there was an implied undertaking of confidentiality concerning the evidence obtained or provided in examinations on discovery. This undertaking is meant to allow the parties to obtain as full a picture of the case as possible without fear that the disclosure of the information will be harmful to their interests, privacy related or otherwise. It appears that the preferred approach is a far-reaching and liberal exploration that allows the parties to obtain as complete a picture of the case as possible. In return for this freedom to investigate, an implied obligation of confidentiality has emerged in the case law, even in cases where the communication is not the subject of a specific privilege. The aim is to avoid a situation where a party is reluctant to disclose information out of fear that it will be used for other purposes. The aim of this procedure is also to preserve the individual's right to privacy. The purpose of the examination is to encourage the most complete disclosure of the information available, despite the privacy imperative. On the other hand, if a party is afraid that information will be made public as a result of an examination, that may be a disincentive to disclose documents or answer certain questions candidly, which would be contrary to the proper administration of justice and the objective of full disclosure of the evidence. It is difficult for the parties at the examination on discovery stage to assess the relevancy of the evidence, and the confidentiality undertaking helps to ensure that the parties will be full and frank in exercising their examination on discovery obligations. The same rationale applies in the context of pretrial settlement negotiations and mediation. So, a couple things. Well, one thing. And it's come up a few times, and it probably will later. The privacy interest of, that the parties in a negotiation, at a trial, what have you, they want them to feel safe disclosing information without fear that it would be leaked, and damage their interests. Totally a legitimate concern. However, Jimmy and I were both in receipt of material that belonged to the government. And how do I put it? It's like the arguments like these are so, they feel like they're like 3 steps removed from like the situation we're arguing for, the situation at hand and before the courts. Sorry. Oh, Phoenix, you're gonna spoil it. Don't say anything. Sorry, I just got a notification. I think they edited it, the ruling, and put my name on it. Oh, they're gonna re-release it? I guess they're gonna... Okay. There's another decision coming out tomorrow, which is probably an edited version of the one that we were looking at. Okay. Yeah, they argue for this really maximal approach that kind of treats all parties in these matters as equals, be it like the government, the police, citizens, businesses, it was Justice Thompson. Yeah, it's it just doesn't feel applicable. I'm I'm not a lawyer, this is not my venue. But the first day of argument was all Crown, Leslie Ruzicka, and so little of it had any relevance to what we were in possession of. A lot of it was civil matters, like the sponsorship scandal, which wasn't civil, but it was it was a private entity, and its dealings with other parties, you know what I mean? Even though it was criminal. But I couldn't find cases where they were actually dealing with something like a government document, a police document, a crown document that, maybe that's why they were so vehement about it, is because it was like a leak of something from, not their department, but like, it's in their house. Maybe that's why they were felt so personal. I don't know. It's really hard like reading a lot of this stuff because it's just so detached. But at the same time, like look how much time Thompson spends hashing it out, and it's like very little of this. The only part that feels relevant to us is that it is it's disclosure. That's it. There's that it had disclosure material. Anyways, paragraph 22. It is expressly stated in Globe and Mail that the confidentiality undertakings arising, undertakings arising during settlement negotiations apply only to the parties to the negotiations and their agents. And the obligation does not and cannot extend to the media. Bam! Provided a journalist does not participate in the breach of these undertakings, a publication ban is only appropriate where the Dagenham-Mentag balancing test supports it. A win. When considering the deleterious effects of the ban, Justice Label pointed to the clear public interest in the subject matter of the negotiations. He noted that the order would prevent the story from coming to light, stifling the media's exercise of their constitutionally mandated role. At paragraph 98, he wrote, as discussed earlier in these reasons, I am reluctant to endorse a situation where the media or individual journalists are automatically prevented from publishing information supplied to them by a source who is in breach of his or her confidentiality obligations. This would place too onerous an obligation on the journalist to verify the legality of the source's information. It would also invite considerable interference by the courts in the workings of the media. Dodoy. It would also invite considerable interference by the courts in the workings of the media. Like, fucking put that on a tattoo. Furthermore, such an approach ignores the fact that the breach of a legal duty on the part of a source is often the only way that important stories in the public interest are brought to light. Imposing a publication ban in this case would be contrary to all these interests. The court quashed the Chamber's judge's orders, drawing the Dagenham-Mentag conclusions that the ban was not necessary to prevent a serious risk to the proper administration of justice, and the salutary, I don't know what that means, effects of the ban do not outweigh its deleterious effects. Returning to the case at bar, here we go. This application occurs in the context of a judicial proceeding, as was the case in Globe and Mail. Although there are dicta injument, I don't know what dicta means. At paragraph 21, although there are dicta injument at paragraph 21, I assume they mean I don't know what dicta means. If anyone knows, please tell me. Paragraph 21, that the open court principle is not in play until trial. Globe and Mail indicates that Section 2A Charter Press Freedom Considerations in the context of a judicial proceeding combine to trigger the requirement to apply the Dagenham-Mentag framework before issuing a publication ban. In Sherman Estate v. Donovan, the court underscored that the open court principle is engaged by all judicial proceedings, and the term of the order sought by the Crown, which seeks to enjoin media publication of the disclosure materials, certainly, as Justice Label put in Globe and Mail, looks like and sounds like a publication ban. Dodoy. Furthermore, there is no evidence that the journalist participated in the breach of the undertakings associated with the Crown's disclosure. In these circumstances, I conclude that in order to secure an order prohibiting publication of disclosure, the Crown must meet the Dagenham-Mintuck threshold. Here we go. The Dagenham-Mintuck framework has undergone some modest refinements since Globe and Mail. In Sherman Estate, the court recast the test as 3 prerequisites for the applicant to establish before a publication ban or other limits on the open court principle may properly be ordered. 1. Publication poses a serious risk to an important public interest. 2. The order sought is necessary to prevent the serious risk to the identified public interest because reasonable alternative measures will not prevent this risk. And 3. As a matter of proportionality, the order's benefits outweigh its negative effects. To those on Instagram, the link is in my bio if you want to watch on Twitch, where you can see my screen and chat. Excuse me. Where was I? 26. I acknowledge the strength of Ms. Ruzicka's arguments that one practical benefit of the Juman approach is that it would require immediate application before publication of disclosure, thus preventing a situation where, as in Globe and Mail, publication occurred before a judge had the opportunity to consider issuing a publication ban. In fact, in the case at bar, Mr. Ruiz published an article online that referenced the Crown disclosure, but he has taken down the article pending this judgment. And he advises the court that he will continue to abide by any publication restrictions. What I can say to that is, it's kind of, there's a way to misread that, because I said that I would abide by, any restrictions that were put in place, like until Justice Thompson made the decision, because obviously we didn't know what he was going to decide, and we were debating. Well, we were trying to figure out what to do with the interim ban. And Ruzicka wanted a stricter publication ban. She wanted the whole thing sealed, all the court proceedings, everything, that we weren't allowed to talk about a fucking thing. And we were like, that's extreme. And Thompson agreed, but couldn't come up with like a good definition in the moment. And yeah, I spoke up and was like, we were under the impression the publication ban expired a couple of weeks before. And I mentioned that, it had expired, and me and Jimmy Thompson, have both, not published. We've both operated, in good faith. This is before the courts, and we're just, we're waiting. So there's no need to put an even stricter ban on. And I said that we would, abide by the spirit of, the temporary injunction, even though it expired. That's what I said. Not that, I will obey dutifully. Anyways, sorry, sidetrack. Here we go. However, as I read Justice Label's reasons in Globe and Mail, and particularly the cautionary language about interfering with the work and operations of journalists, there is no support for the imposition on journalists of a general duty to make an application before publication of material that comes into their hands by way of a source's breach of legal obligations. The Dagenham-Mintuck analysis. The first consideration when applying the Dagenham-Mintuck test as reformulated in Sherman Estate is whether the publication poses a serious risk to an important public interest. In paragraph 42 of his reasons for the court in Sherman Estate, Justice Justice K issued a reminder to be cautious and alive to the fundamental importance of the open court rule, even at this first stage. I bear this caution in mind when I conclude that an important public interest is engaged: the proper administration of criminal justice. 28. Further, I conclude that the level of risk to this public interest is serious. The journalists assert that there is no serious risk to the proper administration of justice because the expected content of the reporting will not interfere with either the RCP operations to enforce the injunction or the ongoing contempt proceedings. This concern, however, is the chilling effect on full and candid disclosure that could result from the prospect of disclosure being published. Minimizing the impediments to proper disclosure is of ongoing importance in this case, but it is also important to all other criminal cases, present and future. In Sherman Estate, the court recognized that some important interests may transcend the interests of the litigants in a particular case. The right to make full answer in defense, the associated imperative to protect against wrongful convictions, and protecting the viability of prosecutions pending trial are fundamental elements of a properly working criminal justice system. Full and candid Crown disclosure is foundational to these fundamental elements, and the Supreme Court Full and candid Crown disclosure is foundational to these fundamental elements, and Supreme Court of Canada cases such as Lac Damiette and Juman have expressly recognized this important rationale for the undertaking that attaches to disclosure. Indeed, as recognized in the report of a committee chaired by the Honorable Arthur Martin, the report of the Attorney General's Advisory Committee on Charge Screen Disclosure and Resolution Discussions. Even isolated incidents of disclosure being made publicly available can potentially persuade large numbers of already reluctant witnesses to refrain from cooperating. And the administration of justice is highly dependent upon witnesses coming forward to provide information that will lead to the proper conviction and punishment of those who have committed crimes. We're gonna save that somewhere, and we're gonna come back to that. Where was I? Those were referred to with approval by this court. Sorry, 1 second. Okay. These conclusions were referred to with approval by this court in R.V. Bassey, Par 18, in the course of Justice Mackenzie's review of various compelling reasons for recognizing an applied undertaking rule in criminal proceedings. The problem then is that the prospect of publication of disclosure material might chill not only full and candid disclosure of material in the hands of the police and the Crown, but it also might stand in the way of important information making its way to the police and the Crown. I have a reaction to that I am holding in. There are two cogent points put against these concerns. The first is publication of disclosure is a possibility that is already present because of the prima facie right to witness and report on proceedings in open court. This is a fair point, but the argument cuts both ways. There may already be some degree of chilling influence caused by the possibility of disclosure heightens the public interest in minimizing further disincentives to the free flow of information from the public to the police, from the police to the Crown, and from the Crown to the accused. The second point is that the concerns about citizens not coming forward or the police and Crown not making proper disclosure available or not making proper disclosure are overblown because each of these groups can be expected assiduously, I don't know what that means, expected to assiduously attend to their responsibilities as citizens, police officers, and officers of the court. This argument would have traction in a more perfect world. However, persuasive authorities have recognized the very real prospect of citizens who might otherwise provide information not doing so if there is an increased risk of publicity. In House of Lords, blah, blah, blah. etc., etc. Moreover, I do not accept that the police or even Crown Counsel are immune to conscious or subconscious lapses from providing proper disclosure, despite the very serious disciplinary consequences that can result from failure to perform this important duty. In R.V. Stinchcombe, Justice Sapinka wrote, "The right to make full answer in defense is one of the pillars of criminal justice on which we heavily depend to ensure that the innocent are not convicted. Recent events have demonstrated that the erosion of this right due to non-disclosure was an important factor in the conviction and incarceration of an innocent person. In Royal Commission on Donald Marshall Jr., findings, blah, 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 the Marshall Commission report, the commissioners found that prior inconsistent statements were not disclosed to the defense." Wow, Crown didn't disclose something. Wow, crazy. This was an important contributing factor in the miscarriage of justice which occurred and led the commission to state that anything less than complete disclosure by the Crown falls short of decency and fair play. The commission recommended an extensive regime of disclosure. The Marshall Royal Commission is one of several Canadian inquiries into problematic prosecutions. Chapter 11 of the report of the Heads of Prosecution Subcommittee, The Path to Justice, Preventing Wrongful Convictions, 2011, lists other commissions of inquiry that examine the role inadequate disclosure plays in the increasing the risk of wrongful convictions. Dalton, Parsons, and Druke in 2006, Driscoll 2007, and Milgaard 2008. Paragraph 32. Full and candid disclosure reduces the risk of wrongful convictions while at the same time protecting the viability of prosecutions. Regrettably, prosecutions continue to occasionally collapse because of disclosure failures. Even serious cases built upon very expensive and time-consuming police investigations. For example, see blah blah blah. 33. Having found a serious risk to the proper administration of criminal justice, I turn to the second Sherman Estate requirement, to consider whether there are reasonable alternative measures that will prevent the risk. There are not. The journalist suggests the possibility of contempt proceedings against the person or persons responsible for breaching the disclosure undertaking if they are identified, thus deterring others who might be tempted to breach the undertaking. Recall, however, that there are more than 400 criminal contempt prosecutions in this action, and unlike in civil proceedings, the discovery obligations are not reciprocal. The Crown cannot deliver interrogatories to alleged contemners or examine them for discovery. Further, the alleged contemners cannot be compelled to testify at their trials. There are no practical means to attempt to discover the identity of the source of the breach. The suggested alternative measure is hollow and I find not reasonable. Third and final Sherman Estate hurdle for the Crown to clear is to establish that the benefits of the proposed ban outweigh its negative effects. I say at the outset that there are substantial negative effects of the proposed ban. The starting point must be that any impediment to a journalist being able to report on a subject as they see fit is a substantial negative effect. The importance of the media's fight our right to report and the deleterious effects of publication bans that restrict information on the practices of government, including the police, was emphasized by the Supreme Court of Canada in R.V. Mentuck, 2001. Okay, here we go. The deleterious effects, however, would be quite substantial. In the first place, the freedom of the press would be seriously curtailed in respect of an issue that may merit widespread public debate. A fundamental belief pervades our political and legal system that the police should remain under civilian control and supervision by our democratically elected officials. Our country is not a police state. Is it though? Isn't it? It kind of is. It's just kind of. Sorry. I got derailed. Canada is a police state. Make sure you got that on the record. The tactics used by police, along with other aspects of their operations, is okay. To be clear, Justice Thompson did not say that Canada is a police state. That was me. That was me putting that in. The tactics used by police, along with other aspects of their operations, is a matter that is presumptively of public concern, restricting the freedom of the press to report on the details of undercover operations that utilize deception and that encourage the suspect to confess to specific crimes with the prospect of financial and other rewards. Prevents the public from being informed critics of what may be controversial police actions. Wow. As this court recognized in Irwin Toy v. Quebec, participation in social and political decision-making is to be fostered and encouraged, a principle fundamental to a free and democratic society. Such participation is an empty exercise without the information the press can provide about the practices of government, including the police. In my view, a publication ban that restricts the public's access to information about the one government body that publicly wields instruments of force and gathers evidence for the purpose of imprisoning suspected offenders would have a serious deleterious effect. There is no doubt as to how crucial the role of the police is to the maintenance of law and order and the security of Canadian society. But there has always been and will continue to be a concern about the limits of acceptable police action. The improper use of bans regarding police conduct, so as to insulate that conduct from public scrutiny, seriously deprives the Canadian public of its ability to know of and be able to respond to police practices that, left unchecked, could erode the fabric of Canadian society and democracy. Bro, who is this judge? I don't remember who the judge is in RV Mentuck, but we're going to find out. Paragraph 35. It is investigative journalism, as contrasted with uncritical parroting of news releases issued by communication departments, that plays a particularly important role in maintaining a free and democratic society. And, as Justice Label made clear in Globe and Mail, breaches of legal obligations by sources willing to act as whistleblowers may be the only way some important stories are brought to light. In the case at bar, I am satisfied that the respondent journalists are accomplished at their craft, thank you, and that they are intent on carrying out investigative journalism in relation to the Fairy Creek protests and the RCMP enforcement operation. Each journalist did some research around Crown disclosure they received. In the course of this due diligence, the RCMP and Crown were contacted for corroboration and further information. This application is the response to those requests. Yeah. Friendly reminder that I did the professional thing, reached out for comment to RCMP and then the BC Prosecution Service to confirm some details. I was told they would get back to me by my deadline. They didn't get back to me by my deadline. I offered to work with them on a deadline if they did want to make comment. They didn't respond, and then 2 days later, I get an injunction via email. That's how I was treated when I went to the government for comment. They hit me with an injunction. So yeah, super cool. Paragraph 36. The unlawful RCMP actions that impaired the media's work at Fairy Creek during the early months of enforcement operation were the subject. It was not early. Sorry. Get a little hot. It wasn't until like September that things actually changed. And by change, I mean some of them, more than half of them, started wearing identification. The unlawful RCMP action that impaired media's work at Fairy Creek, blah, blah, blah. Of course, my later reasons refusing an application to extend the injunction, I found that improper constraints on the media continued. They did continue. Thank you for noticing. As he says in his decision, the evidence before me indicates that the RCMP have now stopped searching pedestrians, but they continue to enforce exclusion zones that are more expansive than the law permits. Moreover, the media's right of access continues to be improperly constrained. One prominent example of difficulties journalists continue to face is the CBC camera crew that was made to hike 7 kilometers in and 7 kilometers out with their heavy equipment to an area where RCMP enforcement activity was occurring on 26th of August 2021. The respondent, Jimmy Thompson, has a master's degree in journalism and his work has been published in various national and international media outlets. He has won awards for his work and is a national director of the Canadian Association of Journalists. He deposes to the challenges in obtaining information from the RCMP about their Fairy Creek enforcement operation. This is from Jimmy's affidavits. I have no confidence that I will be able to obtain the Crown disclosure material received from a source through an access to information and privacy request to the RCMP based on my unsuccessful past requests for information. On May 17th, RCMP officers blocked me from accessing the protest site as they began their enforcement actions. I was subsequently part of a successful media challenge to vary the existing court order to allow media access. In the following months, Capital Daily reported numerous times on multiple aspects of the protests. For example, I led an investigation into the RCMP's justification for its use of pepper spray on August 21st. On November 1, 2021, Capital Daily published an article resulting from that investigation titled Investigation, RCMP Misled Public About Pepper Spray Incident at Fairy Creek. A true copy of that article is attached to my affidavit as Exhibit C. The RCMP refused to provide evidence like flight logs or correspondence to aid or inform that reporting. Formal requests under Access to Information Act, have likewise been met with resistance. On August 25th, I submitted a request to the RCMP for Fairy Creek. Basically the expense report and whatnot, and received a 9-line breakdown of expenses. No further documentation of any kind was released to me. I've had no response beyond an acknowledgement of receipt to 2 requests I made September 21, 2021, as of March 15, 2022, date of swearing this affidavit, past the 30-day statutory deadline set out in Sector 7 of the Access to Information Act. I made a request I made on September 27th for any records, including but not limited to flight records, hospital records, WorkSafe BC reports or correspondence, related to a medical evacuation of an officer from Port Renfrew Fairy Creek area on August 21, yielded only a letter dated January 16th saying no records have been located, which is attached to this, my affidavit, as Exhibit E. On January 18th, I filed access to information and privacy requests seeking information connected with the Crown disclosure material received from a source. On February 2nd, 2022, I filed a request for particular documents connected with Crown disclosure. 5 days later, the RCMP requested an extension of 30 days beyond the statutory limit of 30 days to respond. I have not received any further response as of March 15, 2022. This pattern of late, missing, or severely redacted records impacts my ability to report effectively on this time-sensitive matter of public interest. And I'm sure that's pared down. I'm sure he could go on and on about, pointless ATIP requests. I've got a few of my own. To anyone thinking of reporting on the RCMP, good luck with the ATIP process. You will get nothing. Anywho, to the same effect, Brent Jolly, the president of the Canadian Association of Journalists, deposes to his efforts to overcome RCMP restrictions on media access at Fairy Creek. And his evidence is that the access to information and privacy process has been an incomplete workaround to obtuse RCMP media processes. Paragraph 39. I am sympathetic to the journalist's arguments that investigative journalism is critical to democracy, that unlawful RCMP actions have impaired the media's ability to do their work at Fairy Creek, that the RCMP is not respecting the access to information and privacy process, that the journalists have not participated in any breach of confidentiality, and that in these circumstances they ought not to be constrained from publishing the Crown disclosure material that has come into their hands. Paragraph 40. Here we go. Oh boy. Okay, paragraph 40. On balance, however, I conclude that the benefits of a publication ban outweigh its negative effects. There you have it. On balance, I conclude that the benefits of a publication ban outweigh its negative effects, as substantial as the negative effects are. Publication of the disclosure material would put at increased risk the integrity of the disclosure regime in the many cases underway in this action. To those that just joined on Instagram, you can watch on Twitch. I'm actually almost done, though. But I'll read that first sentence over. Hello, Colin. On balance, however, I conclude that the benefits of a publication ban outweigh its negative effects, as substantial as the negative effects are. In short, Justice Thompson is upholding the publication ban. Cool. Okay, keep going. Publication of the disclosure material would put at increased risk the integrity of the disclosure regime in the many cases underway in this action, and the disclosure regime in other cases. While there may not be readily apparent concrete impacts on individuals, I must be attentive to the less immediate and less tangible negative effects of publication as instructed by Sherman Estate. The importance of full and candid police and Crown disclosure, and the importance of the citizenry's willingness to provide information to the police are so thoroughly fundamental to the proper administration of the criminal justice system that I conclude, albeit with some unease, that the important interests persuasively articulated by the journalists must give way. Fuck. It's just... Fuck, man. Sorry, I'm taking a minute to save the screenshot, and then I'm going to upload it to Instagram. Okay, there's only a page and a bit left. I'll finish it up. Order. The order will include a publication ban term. That until further order, the alleged contemners and anyone having knowledge of the order, including members of the media, are prohibited from directly or indirectly publishing or broadcasting or reproducing any disclosure or disclosure information except as provided for by other terms in the order, or until the disclosure or disclosure information becomes evidence at trial or evidence on the hearing of the stay application being advanced by various alleged contemners. The Crown seeks the return by alleged contemners of all copies of any disclosure or disclosure information provided by them to any member of the media or to any other person or parties other than counsel for the accused, to Crown Counsel. The time frame for return of the material will be on or before July 8th, 2022. When imposing a publication ban, the court is required to restrict the order as far as possible without sacrificing the prevention of the risk. R.V. Mintuck at paragraph 36 I agree with the journalist that the proposed term that the journalist disgorged to the Crown the disclosure material in their possession is not necessary. I also agree with the journalists that term 7D of the orders sought by the Crown is in its present form overboard. It would leave journalists unsure of the extent to which they could communicate with alleged contemners, generally or in relation to this action in its various aspects, and is unnecessary to protect the interests underlying the publication ban. Accordingly, this term will simply be that the alleged contemners shall not provide, directly or indirectly, any member of the media with disclosure information. Term 9 of the orders sought attempts to define actions which may constitute contempt of court. And I agree with the journalist that this term is unnecessary. There is no reason to dispense with the respondent journalist's approval of the form of order. As noted above, although the contempt prosecutions in this case occur under the umbrella of a civil action, they are criminal proceedings. The court file maintained at the Vancouver Registry, and I direct the district registrar, that access to all parts of the court record that relate to the contempt proceedings, including affidavits and audio recordings, is to be governed by the court's policy on access to the court record. On this basis, the interim sealing order that I made on the last day of this hearing is discharged. 48, there is liberty to apply regarding the terms of the order. Thompson J. That's it. That's it. Yep. Publication order stands. And that sucks. Someone please ask me a question or something. Fuck. Yeah, I don't know what to say. Yeah, it's pretty fucked. I talked to Jimmy about it a bit, and he said it was a roller coaster reading it. Because, like, 3/4 of it is, like, seeing the importance of what we're doing, and then talks about the importance of investigative journalism, and then ends it with, you know, this public interest in the criminal process is more important. And you're just like, what the fuck? Like, where did that come from? Yeah. Yeah. Yeah, it's not like me and Jimmy are going to appeal this or something. We can't even afford lawyers for the first case. Yeah. Yeah. It's so weird hearing their arguments that, like, oh, the Crown didn't provide full disclosure back when there was no disclosure regime. So now we have to have this strict disclosure policy and privacy policy. I don't even know what I can say about it. Fuck. Like, I can't even talk about what was leaked to me. this is so fucked because I can't even make my argument without breaking the law. And what I did ask in court was that my case be heard on the merits of my work, because there was no way I was gonna read this gigantic fucking document, like 1,000 pages of legal argument. And he let me submit my affidavits. Yeah, Thompson, like, we actually thought Thompson was going to be, like, firm yet fair in his ruling. This really is a curveball. It's just weird. Yeah. I already had a shower, but I kind of want to go just have a bath or something. Like, start this day fresh, because it's kind of fucked way to start my day. So, thank you for listening, watching. Excuse me. Sorry about the cog. Okay, I'm gonna stop recording. I'll put this up. I'm sure I'll have lots of questions later. I just posted my screenshot of the paragraph 40. Thank you all. Peace.